Good afternoon. Another drive home point, and this burns me up to no end. I've said it before, and it involves workers' comp. And when a workers' comp attorney tells his client that he or she cannot file a Social Security disability claim while they have any kind of open workers' comp claim, it's totally false. And here's an example of where it's done a ton of harm. I'm livid. Okay, so if a person, so in this instance, for instance, person gets injured, say in 2017, beginning of 2017. They have a sporadic work history due to raising children and all sorts of other things, but they are insured for Social Security disability. But their date last insured is, say, middle of 2018. So they immediately have a workers' comp claim from 2017 because it was a workers' comp issue. Not getting paid anything, but apparently there's an open case for the injuries. And 5 years go by, and I think, misinformation provided by workers' comp attorney, not to file, can't file, blah, 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 not explaining anything. Perhaps somebody doesn't know, and therefore is not explaining it. And I'm not saying a workers' comp attorney has to speak to Social Security disability at all necessarily. That's not necessarily his field, and each person should kind of have to have their own responsibility in finding out what may apply to them when they're disabled. However, if someone is overtly telling a client you cannot file for Social Security disability, perhaps because it would be inconvenient for the lawyer, I don't know. It shouldn't be if they were, I don't know, paying attention. It doesn't have to be. Anyway, 5 years later, now the person who didn't know they should be doing certain things for Social Security disability, they had a 1.5 year window of insured status that is now way in the past. Now learns that he can file a Social Security disability claim, despite the fact that the DLI is in the past, because there is that 1.5 year window between the work stoppage from the injury and when the DLI expired. So there is one bite at the apple, meaning one application likely that can be had. And it would be arguing disability onset the day of the injury. And the only evidence that can be really generally considered in terms of finding an onset, there has to be enough evidence in that 1.5 year window. Nothing after that. And as you know, workers' comp puts the noose around your neck and doesn't let you treat the way you as an adult think you should be treated, and or as your primary care thinks you should be treated. Don't get me started on the laws on this. I have a cold and I'm really ticked off. But so now I'm gonna do my best to help this person because I think they've been totally screwed. We have one shot at the apple. I can't even give advice. I could still give advice as to future things to follow up on, but none of that is going to go towards onset. And the first requirement to get, the first hurdle the person has to get through is persuasive medical evidence existing between 17 and middle of 18 that shows that legally disabled at that time. Then, of course, after that is done, the next step is to show that that disability has continued through every year to the present. So you can't have any gaps. Who knows if there were gaps? Workers' comp, again, has that noose around your neck and doesn't let you treat the way you need to be treated. I see a lot of people go without recommended treatment because workers' comp is sitting on their duff. I don't know to what extent the workers' comp attorney is required to be competent to start making motions and pushing through the courts to require the workers' comp attorney, workers' comp carrier to get off the pot and start either saying it's MMI or confirming and allowing various therapies, whether it's surgery or physical therapy or injections or whatever the case may be. So I'm really confused on that. I wouldn't mind hearing from, and I know most workers' comp attorneys know exactly what they're doing and they're not screwing around. But in this case, I'm a little ticked off on behalf of this person who has been disabled for now, what is this? 7 years? No longer insured for SSD. That little window is in the past. We have it still because the person never filed and lost. But the chances of prevailing have diminished incredibly so because there's no useful advice as to how you can improve that evidence because it's in the past. We don't have a little time clock where we can, a little time machine. So I don't know what's going on with some of these rogue attorneys that tell their clients that they can't file for SSD. So what happens if she doesn't prevail? Well, her Social Security retirement will be decreased because now she has even less of the 35 years that are going to be counted and worked into her Social Security retirement amount, because many of them are going to be zeros because they're not counted as disabled because she wasn't able to have a case to prove that she was disabled. So not only is the damage a decimation of her retirement, which seems very unfair, but also without being able to win, the person is now not going to be eligible for Medicare until age 65. So there's multitude of years of either no insurance or state welfare, Medicaid insurance, or Medi-Cal or whatever the different states call them. So I have to, for everyone who's dealing with workers' comp, you have to know and double check. It's trickier with a dual case, but there are also, I will add this, very rarely is someone's own woman in her 50s and above, very rarely is the only impairment we have that which occurred from the work-related incident. So all those other, and I have a video on this, all those other impairments, maybe we have arthritis because dang, we're getting older, or maybe diabetes that's a little uncontrolled, or uncontrolled blood pressure, or maybe some cellulitis and I get wounds on my legs, or swelling and I have to elevate my things that are unrelated to the workers' comp injury. Don't try to shove those things into workers' comp's face because that's a trap. You really don't want all these. They're probably not related, number one. Number two, having them under workers' comp means you have no control over your treatment for those now. And you can't work them up to the full health that you would be in a perfect world that will also support your disability case. Because remember, Social Security disability is all of your impairments, not just the big bad one that took you out of work. That took you out of one occupation. You've got, for lack of a better description, 11,999 more occupations that we have to prove you can't do. So use those other unrelated things through your own health insurance or your Medicaid if you have it, or your employer, if your spouse has benefits for you, use it and go full health on determining what those impairments are, how they limit you. As I say, every little hangnail, and I'm exaggerating, but it's not far from the mark if it's something that affects your ability to do some little tiny function. Okay, I'm gonna get off my little rant here, but this really, really broke my heart. Nicest person in the world, and that ship has left. We're gonna go to try to drag back 6 years ago, a year and a half of time. But there's so much more limitation now to what we can do in terms of gaining, evidence development, improving what was accurately true back then, but might not have all of the evidence. Because again, A, it's in the past, they didn't have advice, and B, workers' comp had that news. Anyway, workers' comp people, you can file. I don't care what anybody tells you. All right, bye guys.